expert evidence or not expert evidence. We shall go through it later. So before we start our class, all of us know that those who are in the legal profession always ask three questions: what, how, why. Suppose this is the last one, why is omitted, then it cannot be an intellectual exercise. Anybody can say what it is, anybody can say how it is, but why? That question has to be answered. So my attempt is to answer these three questions: what, how, why. Now, Section 5 of the Indian Evidence Act declares that evidence may be given only of facts in issue and facts declared relevant by the Act. So unless opinion of a person is a fact, no evidence may be given of it. So the first question is whether opinion of a person is a fact as defined in the Indian Evidence Act. We know that Section 3 of the Act defines the term facts. The second part of this definition declares that a mental condition of which a person is conscious is a fact. Opinion is a mental condition. It's actually a belief. It is actually a judgment. A judgment of a court is nothing but the belief of the court, which you will get from the definition of proof. Belief means it is your opinion. So opinion is equal to belief, belief is equal to judgment. So opinion is a fact because it is a mental condition. Illustration D of the section makes it very clear. The following sections in the Indian Evidence Act relate to opinion evidence. Section 32 clause 4, Section 45, Section 45A, Section 47, 47A, 48 to 50, 73, Section 60 relates to it, 155 clause 1. Now, only sections 45 and 45A relate to expert opinion. The other sections, namely sections 32 clause 4, 47, 48, 49, and 50, relate to opinions of non-experts. So, Indian Evidence Act makes admissible opinion of not only experts, but non-experts also. Now, I think we may not get time to discuss all these provisions, but first we shall go through section 32 clause 4. We will just go through it, that's all. We may not get much time to discuss it. So the requirement of this section is that the person who gives the opinion or who gave the opinion is not available. So non-availability of the opinion, person who gave the opinion is the only reason for admitting it. Here the non-availability may be due to various reasons. The main part of the section gives it. It may be due to death, it may be due to absconding, the whereabouts of the person are known, he has become incapable of giving evidence because of physical or mental infirmity, because of old age, etc., etc. So section 32 clause 4 deals with opinion given by a dead person or a person who is not otherwise available. Now we come to section 47. 47. We are not discussing section 45 now because section 45 deals with the expert evidence, expert opinion. Here we are only going through the provisions which deal with opinions of non-experts. The second one is opinion under section 47. This requires a discussion. The requirements of section 47 are: 1, is necessary for the court to form an opinion, that is to take a conclusion or a judgment, to judge it as to the person who wrote or signed the document. So this relates to handwriting of a person. Handwriting includes a signature also, though it is specifically mentioned or they are separately mentioned. the second requirement is that the opinion is given by a person acquainted with handwriting or signature of the person who allegedly wrote or signed the document in question. Here, why is the opinion, why the handwriting and the signature are separately mentioned? Section 67 also mentions it separately, because to prove the contents of a document, it is necessary to prove either the handwriting or the signature. The reason is that some documents may not bear this signature of the author. Some documents, the author may be a person, the scribe may be a person, but the signature may be another person. The signatory may be another person. The author is the person who signs it, not the person who writes it. This is the reason why they are separately considered. The opinion may be affirmative or negative. That is, whether a person wrote it or signed, or whether he did not write it or sign it. Not only affirmative, but negative also. Evidence is acceptable under this section. Opinion under section 48. Requirements. It's necessary for the court to form an opinion, that is to judge as to the existence of any general custom or right. The person would be likely to know of it if it existed. Now we come to section 49. 49, the requirements are that the court has to form an opinion as to the usages and tenets of any body of men or family. Here, body of men means it may not be an organized one, it may not be a registered one. It may be an association of traders, a collection of traders, or family, okay. Then the second one is that the constitution of any religious or charitable foundation. Here, government does not mean constitution and government. Actually, they do not relate to any states. It relates to any religious or charitable foundation. The government here means only this administration, nothing else. See, the meaning of the third requirement is that meaning of words or terms used in particular districts or by particular classes of people. We know that different words are used in different parts of the same state to denote the meaning of the same thing, or the same word is used in having different meanings. They may have different meanings in different parts of the same state. In Kerala, earlier Kerala actually was divided into three princely states or other states. The southern part came under this Travancore state, princely state. The second, Cochin princely state, and the third was the Madras province of the British Empire. So in these three parts of Kerala, different words are used to denote the same thing, or the same word is used to denote different meanings. Then the second thing to be noted is that the person giving the opinion has special means of knowledge on the matter. This is one of the important requirements of section 49. Now under section 50, again the court has to form an opinion, that is to judge as to the relationship between two persons. Example, the husband and wife, son, adopted son, etc. The person whose opinion is sought to be proved had expressed his opinion about the relationship by his conduct. Here, what is pertinent to note is that under clause 4 of section 32, the subject matter should be a statement of a deceased person or person who is not available. Here it is not a statement that is relevant, it is the conduct of a person. The conduct should indicate his opinion as to the relationship of certain persons. So what is relevant is not the statement, but the conduct of the person. Receiving a person to his home, just as he receives his son, his adopted son, is a treatment of that person. This is what is meant by conduct actually. A general behavior. He did so as a member of the family or otherwise. He need not be a member of the family. Suppose he is accepted by the friends as a legitimate son of a particular person. then that is relevant. They don't have any relationship with him. Still, that is relevant because he need not be a member of the family. A person who is not a member of the family also can, his conduct also can be relevant under section 50. Then he had special knowledge about the relationship. The conduct here means it is outward behavior. Outward behavior. The conduct should be revealed the state of mind, that is the opinion of the person. A mere casual behavior is not sufficient. Conduct is not sufficient. The court should be satisfied that the opinion was a conscious one. The section does not make it a condition that the opinion was expressed before the controversy arose. That is also very significant. Now, these are the sections which relate to opinions of non-experts. We cannot discuss the details because for want of time now. Now we are coming to opinion under section 45. 45. This is the important section so far as practitioners are concerned. One, the requirements of section 45. The court has to form an opinion. That is, the court has to judge upon a point of foreign law, science or art, as to the identity of handwriting, as to the identity of finger impressions. Second, the person giving opinion is an expert in the relevant subject. The expert should appear as a witness in court, subject to section 60 proviso, first proviso. Now, exceptions. There are certain exceptions. The expert is not available for the reasons stated in the provision, section 60 we know, the first proviso. His opinion is expressed in a treatise commonly offered for sale. The third, the treatise is produced in the court. So the ordinary law is that the expert should appear before the court and give his opinion and results. An exception is given in the first proviso to section 60, which says that if the expert is not available for the reasons stated in the provision, means we have already seen section 32, a non-availability of a person may be due to death. Other reasons we have already discussed. Here also the same phrase is used. Then his opinion is expressed in a treatise commonly offered for sale. Commonly offered for sale. It means that it should be a public one. It should be offered for sale. Then a treatise means there should be a scientific, systematic study of the subject. A mere opinion and the grounds may not be acceptable, but there should be a systematic and scientific study of the subject. And the treatise is commonly offered for sale. Then the next requirement is that the treatise is produced in the court. Unless it is produced in the court, you cannot rely on it. Thus, his opinion and the grounds of his opinion are relevant. First proviso to section 60. So the expert may be available, expert may not be available. If he is available, then he should be examined in court. If he is not available, subject to the conditions mentioned in the first proviso to section 60, the opinion may be relied on. The next question that requires our attention is the meaning of expert. The meaning of expert is given in section 45 itself. He is a person who has a special skill. So this takes us to the question, what do you mean by skill? Skill means acquired ability. Nobody gets it at his birth. It has to be acquired. How you can acquire ability? You can acquire ability by making special study, by practice or observation. This is actually what is stated in AER 1931, Privy Council 189. AER 1931, Privy Council 189. So it has to be acquired. Acquired by making special study, practice or observation. So for a person to be called an expert, education is not a must. In all cases, it is not a necessary thing that he should have attended any academic institution. It is sufficient that he has acquired a skill. In Kerala, you know that there is recently there was a murder case. The allegation is that the husband of the victim caused a cobra, a highly poisonous snake, to bite her, as a result of which she died. Earlier also he had made an attempt. The snake was a viper, but she survived. In the second attempt with the cobra, she lost his life. The police officers sought the help of a person by name Vava Suresh, who is totally illiterate. But he has caught numerous snakes, that is about 600 or something poisonous snakes, including king cobra. Of course, he has no academic qualifications, but he is considered an expert because he is in the habit of catching these poisonous snakes. So he knows very well about their behavior, about their habitats, and all these things he knows. So his opinion was taken by the police officers. By no means we can say that he is not an expert, because he has acquired skill by his practice. So far as the Goldsmiths are concerned, the Supreme Court has recognized that a goldsmith is an expert. AER 1983 Supreme Court 168. So a photographer may be an expert. A carpenter may be an expert. He can distinguish between a teak wood and a jack tree. A photographer, he may not have any academic qualifications, but he may be considered an expert if he has acquired the skill. So academic qualification is not a must, but there may be cases where academic qualification is necessary. Then there are different categories of experts. The first category is that experts whose reports may be received without their examination in court. Sections 292 and 293 CRPC provide that the reports of certain officers may be used as evidence in that case without their examination in court. The party who wants any explanation, clarification, etc., may summon the experts, or the court may summon the experts. So here, his examination is not necessary because of the statutory provision. But I may say that section 292 CRPC does not use the term expert. But in section 293, the term expert is used. Anyway, the principle behind this is that those officers are considered experts. That is the reason why the opinion can be admitted in evidence without their examination in court. That is why, since they are experts, they are appointed by the government. Then, the second category is experts whose examination is necessary. Unless there is a statutory provision like section 292, 293, etc. mentioned above, reports of experts can be received in evidence only on their examination court. 1999, Volume 7 SEC 280. Because we have seen that section 60 provides that the opinion, the oral evidence should be direct. Direct means, in the case of opinion, the person who holds the opinion should come and depose before the court. That is a direct evidence. So, the person who holds that opinion, who wants to give that opinion, he should appear before the court and depose in the case. That is direct evidence. The exceptions also we have seen. If this expert is not available, if the expert is not available under first proviso to section 60, his examination is not necessary. Then it is their testimony that is substantive evidence in the case. It is the testimony that is given in the court that becomes evidence in the case. Then what is the use of the reports? The use of the reports is only to corroborate the testimony, which is the substantive evidence. You can see section 157 CRPC. Sorry, section 157 Evidence Act, which we shall discuss later. Then it can be used for contradiction. Now we come to evidence as to competency. Evidence as to competency. When a witness who is not recognized as experts by any statute is examined, he has to first depose, that is in his examination chief, as to his competency. That means he should be brought out in his examination chief, his competency. Then only his opinion is acceptable, because we know under section 104 and 136 of the Evidence Act, when the proof of one fact depends upon the proof of another fact, the second mentioned or the last mentioned fact should be proved first. Before you prove a dying declaration, you have to prove that that person is dead. Before you give secondary evidence of a document, you have to prove that you are entitled to give secondary evidence, that is loss of document, etc., etc. So the witness has to first depose as to his competency, then only he can give his opinion. Otherwise, his opinion will not be admissible in evidence. Then we have to consider the different subjects. Certain areas have been identified by section 45, in respect of which alone opinion can be given. Those areas are 1, foreign law. See, section 38 also you may look into, where the books printed or published under the authority of a foreign country concerned and judgments of foreign countries contained in law journals, and law journals are relevant. Then we are coming to the second requirement, that is science or art area. The term science or art should be given a broad or wide meaning. It's not limited to higher sciences or subjects taught in educational institutions. So typewriting is a science. Identity of typewriter or typewriting, both of them come under this term science. You can refer to AER 1952 Supreme Court 343, AER 1952 Supreme Court 343, which says printing also is a science. Then AER 1996 Supreme Court 1491. Then we come to handwriting. Handwriting includes printing and typewriting. Handwriting includes printing and handwriting. Then finger impressions. So we'll be going through this handwriting and finger impressions later in the course of our lecture. Now there are certain, we have to take note of another section, that is section 51. Section 51, when we consider opinion evidence under section 45, section 51. Section 51 Evidence Act declares that the grounds of opinion of an expert are relevant, though neither section 45 nor section 51 provides that the expert must first give his reasons for the opinion before he deposes to his opinion. It is well settled that unless he gives the reasons in the examination chief, his opinion cannot be acted upon. So the expert should first give the reasons for his opinion and then give his opinion on the basis of these facts. Otherwise, it will not carry any weight. AR 1959, Supreme Court 488. AR 1959, Supreme Court 488. The skill and experience of an expert is the ethos of his opinion, which itself should be recent and convincing. It has to be well ordered and convincing. 2012, 8 SEC 263. 263. It follows that the report of every expert or the evidence of every expert should have two parts, namely data part and the opinion part. Data part should contain the facts. The opinion part should be the last one and should be based on the facts. So opinion part and data part. Opinion part without a data part is useless. That is the two citations I have already given. Opinion part without a data part is useless. Then there are certain tests. There are certain tests in the case of experts. The first one is, what is his educational background? The cases in which education qualification is relevant. So that is the first thing. What is his educational background? So he must first depose, I am a master's degree holder in forensic science, etc., handwriting expert, etc. Then he must disclose his experience. That is why in some cases an expert will be asked, how many cases you have dealt with so far? Whether he has sufficient experience in the field, whether he is a newcomer in the field. To ascertain it, his experience will be questioned. Then second one, is he willing to place his investigation for scrutiny by others? Should be open to scrutiny by others. It should not be a secret. It should not be like a trade secret, which will not be disclosed to anyone. That means he must produce charts, maps, photos, and other materials for scrutiny. He cannot withhold them. Then the third one is he willing to give the details of the techniques and the procedure adopted by him? So he should disclose the techniques and procedure adopted by him. He cannot keep it a secret. Somebody will copy it, somebody will make use of it. No. Then he will not be considered an expert. 1999, Volume 7 SEC 280. AR 2017, AR 2010, Supreme Court 806. 2017, Volume 6 SEC 263. Then the fourth test is this. Is he conservative and cautious? What does it mean? By the phrase conservative and cautious, he should always realize that he is a human being and his knowledge is not perfect. There is room for some error, admissibility. He should admit that he is also liable to make errors. So if an expert says that no, my view is the correct one, it is 100% correct, then he is not conservative and cautious. And the court will look upon his evidence with suspicion. So he should be conservative and cautious. That is why in some opinions we see at the foot of the opinion will be in all probability, or the probability is that the admitted writing and the disputed writing are made by the same person. So the word used is probable, probability. It is probable. That's all what they say. It will not that it is written by so and so only. There may be some cases just like a DNA. That's a different one. Then the fifth test is, had he the means of gaining correct information? So whether he had the means of getting correct information. Then the sixth test is, has he any interest in concealing the truth? Has he any interest in concealing the truth? There may be cases in which some mistake has been committed by the aspect. Then he would always try to conceal it. Then the seventh one is the test, do the facts agree with his testimony? So the facts and the testimony should go together. These are the tests laid down in the case of expert evidence. Now section 46 also may be considered. If an expert opinion is relevant, then facts which would corroborate or facts which are inconsistent with that evidence also is relevant. That means the opposite party may adduce evidence, adduce expert evidence also to prove that the opinion of the expert already examined is not acceptable. 2009 14 SEC 677. So expert opinion is given, then evidence may be adduced to corroborate his evidence, and the opposite side may adduce evidence which is inconsistent with the evidence of the experts. Now we have seen that the experts are attempted to be discredited in the box with the views in textbooks. How it has to be done? If you want to discredit an expert who is under examination in court with the views expressed in some other textbooks, there is a procedure. The procedure is, the relevant passage in the book should be placed before the expert. So without giving the book which contains that contrary view, you cannot contradict him. So that is the requirement, precondition. You give him that book so that he may go through it and express his opinion. That is AR 1957 Supreme Court 589. AR 1957 Supreme Court 589. And we have come across many situations where certain suggestions are made to experts. You have given this evidence, but is it not probable that this happened in a different context? Or you put your defense version to the expert who is under examination. What is its relevancy? What is its significance? Suggestions of probabilities is of no use unless there is something in the evidence to make the defense version probable or the prosecution case doubtful. So that means the suggestion should be based on the facts brought out in the evidence. Otherwise, it is of no use. Your suggestion should agree with the facts brought out in the evidence. Then it assumes a significance. Otherwise, it is of no use. See, experts may express his views one way or another, depending upon the manner of questions you put to him. So it depends upon the nature of the questions you put. But the answers may not be the last word. So he would give an answer. That is 2008 13 SEC 515. So the defense version will be always hypothetical. Hypothetical questions are put to him. When hypothetical questions are put to him, the answers also will be hypothetical. That is the significance of it. But if it goes with the evidence already available, then it is of some use. Otherwise, it is of no use. That is the 2008 volume 17 SEC 152. 152. Then, what's the nature of opinion evidence? We know that opinion evidence is an exception to exclusion of hearsay evidence. There are certain categories of evidence. We know that the statements of persons not available under section 32, that is the register, section 6, section 32, section 21 admission, opinion evidence. These are all exceptions to exclusion of hearsay evidence. This is so the nature of opinion evidence is very relevant. If an opinion is given, what is its nature? Opinion evidence is only advisory nature. Advisory nature. What does it mean? It means the court may or may not accept it. It is advisory means the court is not bound by it. The court may or may not accept it, but the decision should be a judicial one. Whether to accept it or not to accept should be a judicial one. It should not be according to the whims and fancies of the judge. So the court is not bound to accept it. That is the meaning of the advisory nature. 1999 7 SEC 280. (2012) Volume 8 SEC 263. 2013 Volume 4 SEC 360. And the latest one is 2017 Volume 6 SEC 263. Jayalalitha's case. Then the opinion is not conclusive. AR 1967 Supreme Court 778. So it is advisory in nature. The court may or may not accept it. The court may reject it for reasons to be given in the judgment. But ordinarily, the court should not interfere with the opinion of an expert. Ordinarily, the court should not interfere with the opinion of an expert. 2012 5 SEC 480. Courts are extremely loath to interfere with the opinion of experts. Then the next sentence is very noteworthy. The opinion of experts deserves respect, but not worship. 2013, Volume 8 SEC 83. You cannot accept it, you need not accept it as gospel truth. You may agree or disagree with him. The only thing is that you have to give your reasons. Then, opinion of an expert may be rejected if it is inherently defective. If it is inherently defective. Suppose he has failed to take notice of a particular fact which is a fundamental for the test, then it has to be rejected even without any objection. 2011, Volume 4 SEC 249. 249. So the court may or may not accept it. The only thing is that the court has to give reasons for it. Then what is the probative value of expert opinion? Probative value of expert opinion. You know that the probative value means the weight that should be attached to the evidence. Every piece of evidence, though admissible, need not carry the same weight. So probative value of an expert opinion, probative value of an opinion of expert does not depend upon any statutory provision. There is no statutory provision relating to probative value of an expert. But we have to notice that the Evidence Act declares it relevant without any qualification. When the Evidence Act declares a fact or evidence as relevant without any qualification, it means it is a substantive evidence. So opinion also may become a substantive evidence. But substantive evidence may be weak or strong. Weak or strong. There are some sections which indicate that the evidence is not substantive. Just like section 30, confession of a co-accused. It says that the court may take into consideration. The section does not declare confession of a co-accused relevant, but it says that it may be taken into consideration. That means it can be used for corroboration only. And if the only evidence is this confession of co-accused, it is a case for discharge of the accused. Then section 34, you can see entries in books of accounts. They are declared relevant. But further it says that alone cannot be a ground to attach any person with liability. So the effect is gone. So an evidence may be substantive, but it may be weak. So opinion evidence is declared relevant. So it indicates that it is a substantive, but it is a weak one because of rule of caution to say that we should not accept it as a gospel truth. So the court must take into consideration the differences between an expert witness and an ordinary witness. 2009, volume 9 SEC 221. So the court has to attach some weight to the evidence of an expert because it stands on a different footing from the evidence of an ordinary man. That is what the Supreme Court has said. Then the next question is whether the court can act as an expert. The court should not play the role of an expert. The court should not play the role of an expert. We shall consider that in detail later when we discuss the section 73 of the Act. This is AR 1967 Supreme Court 1326. AR 1967 Supreme Court 136. The court shall not assume the role of an expert. The court should realize its weakness. Now there may be medical evidence. We are coming to medical evidence. Medical evidence may not agree with the evidence of occurrence witnesses. Occurrence witness. Then what has to be done? We have already seen that the Supreme Court has observed that ordinarily we have to accept the opinion of an expert. But there may be cases where we cannot, where we have to decide whether it is acceptable or not. Here there is a conflict between medical evidence and the evidence of the occurrence witness. We have already mentioned that the expert evidence is not conclusive. Same is the case with the medical evidence, any type of evidence. Medical evidence is not conclusive. In case of conflict between medical evidence and evidence of occurrence witness, prefer the latter. That means the evidence of the occurrence witness. Unless the medical evidence completely rules out the former. So that is the condition. So in case where the medical evidence completely rules out the evidence of the occurrence witness, no importance may need be attached to the evidence of occurrence witness. That is the 2017 11 SEC 195. 195. Because the medical evidence is, after all, an opinion evidence. It is not a direct evidence. Whether the wound was inflicted with a sharpened weapon, the doctor did not see it. He is not a witness of fact. The doctor is not a witness of. So the person who saw the weapon, he says that it was inflicted with a sharpened weapon. So the court will give importance to the evidence of the occurrence witness. Then 2014 volume 5 SEC 398. 2014 volume 5 SEC 398. Then 2012 volume 10 SEC 476. Suppose there is a conflict in the prosecution evidence itself, then it is a manifest defect in the prosecution case. AIR 1977 Supreme Court, AIR 1977 Supreme Court, 2279. So there is a conflict. Now, when medical witness is examined, and it's a case where a weapon was used in the course of the incident, there is a duty on the part of the prosecutor. The prosecutor should show the weapon to the medical witness. He should show the weapon to the medical witness. I have seen many experts in this field always carrying a scale with them. 1 foot scale they will carry with them. And when their opinion is asked about a certain measurements, size, etc., then they would just measure it in open court. And they said that, yes, it is probable that it could be inflicted this weapon. So it is necessary that it should be shown to him so that he may give the evidence. In many cases, the prosecution, the investigating officer must have shown this weapon to him. But there is no evidence in the case, as we all know. Evidence is the statement given in the box. So he should state it in the box, and he should say, or he should show to the court why he expressed that opinion. For that purpose, he measures it. Otherwise, it may sometimes result in aberration in the course of justice. If the weapon is not shown to the witness, medical witness, sometimes the casualty will be justice. AIR 1976 Supreme Court, 2423. 2423. But this does not mean that this is an invariable rule. There may be cases where that is not necessary and the showing of the weapon is insignificant. One such case is reported in AIR 2017 Supreme Court, 2124. 2124. That is a case where the showing of this weapon was not at all necessary, or it was insignificant. Insignificant. And the doctor is not a witness of fact. The doctor or the medical witness is not a witness of fact. AIR 1960 Supreme Court 706. And his evidence with regard to the cause of incident, cause of this occurrence, is only hearsay. That is opinion evidence. But with regard to the facts, he noticed, okay, that is not hearsay. But with regard to the opinion as to the occurrence, his evidence is hearsay, because he did not see the witness the incident. AIR 1960 Supreme Court 706. And when his report is or when he is examined, where the report is available, what is the purpose of this report? What is the nature of this report? Examination of doctor is necessary because the only provision which speaks of the use of this document is section 157 and 145. 145 and 157. If the witness is not available, then it comes under section 32. If the doctor is dead, or the doctor is not available, then section 32 comes into play. Here the doctor is examined. The question is, when the doctor who prepared the report, say postmortem certificate, wound certificate, etc., the question is, what should be the nature of his evidence? Is it sufficient that the report is or the certificate is marked through him? Or when he is examined, can the prosecutor first ask him, have you given a report or a certificate to the investigating officer? Yes. Can you identify the signature? Yes. This is my signature. This is this bears my the hospital seal of the hospital also, and the court marks it. Is it the correct procedure? It's not the correct procedure, because the purpose to which it can be put is given in section 157. The nature of this document is that it is a previous statement of the doctor. It's a previous statement of the doctor when he is examined. So he is going to give evidence with regard to the entries in his written statement, a statement in writing, which is his report. Then what is the nature of this evidence? The only section which is attracted, the two sections which are attracted are one, section 145, that can be used by the opposite side only, 145 contradiction, otherwise he is declared hostile. Then section 157. 157. What does the section 157 say? Section 157 says that in order to corroborate the testimony of a witness, in order to corroborate the testimony of a witness, any former statement made by a such witness relating to the same fact at or about the time when the fact took place, or before any authority legally competent to investigate the fact may be proved. So what is necessary to attract the section? To attract the section, there should be testimony. That is the opening words of section 157. In order to corroborate the testimony of a witness. So section 157 presupposes the witness having given testimony. So after giving the testimony, this situation arises. He can use this statement, that is his report or certificate, which is the former statement, to corroborate his case. That means this is not a new case for me, but this is my opinion, or this is my case at the appropriate time itself. See, to attract the section, any former statement made by such witness, that is the medical witness, relating to the same fact at or about the time when the fact took place. What is the fact here? What is the fact mentioned in section 157? The fact mentioned in section 157 is not the occurrence in the case alleged by the prosecution. It is not the incident on the basis of which the case was registered, but it is the fact noted by the doctor in his report. That is examination of the wounds, examination of the dead body, etc. That is the fact. That is the fact in respect of which he gives evidence, not the occurrence. So if he has noted these injuries in his postmortem certificate, he has noted the certain other facts in the wound certificate, then he should first depose to it. He must first give his testimony. Yes. Now, so examination of doctor is necessary. and he should depose to the contents before the document is tendered in evidence. So he should depose to the facts. He should testify the injuries noted by him in his report. Because of section 157. 2011, volume 8, SEC 80. So the examination of doctor is necessary if he is available, and before the document is tendered in evidence, he should depose to the contents of the document. That is section 157, 2011, 8 SEC 80. Now we come to fingerprints. The Supreme Court has said that science of identifying thumb impression is an exact science. Section 45 covers fingerprint also, finger impressions. It does not admit of any mistake or doubt. So it is an exact science. It does not admit of any mistake or doubt. 1980, volume 1 SEC 487. Now, for this purpose, we know that in criminal cases, finger impressions are taken. Fingerprints of the suspect is taken. Can the court compel him to give finger impressions? Now, after this amendment also, it is necessary. It is not hit by Article 20, Clause 3 of the Constitution. If it does not give it, adverse inference may be taken. 2007 judgments today. (2017) volume 5 SE 4. That is volume 2017, volume 14 SEC 516. Parallel citation is there. 2017, volume 14 SEC 516. But evidence of this fingerprint aspect is not substantive, or it is not considered substantive. I have already told you that. Section 45 declares it relevant. Once it is declared relevant, it means it is substantive. So we cannot say that it is not substantive, but as a rule of caution, we always seek for corroboration. I think that is the proper view. Can be used for corroboration. For example, a recovery. 2010, volume 2 SEC 748. Because with regard to the incident, that may not be necessary. Only in that sense it is stated that it is not a substantive evidence. It proves in cases like theft, etc., it proves the presence of the accused. It proves the presence of the accused at that place or on that object, and it can be used for corroboration then. So whether it is a substantive evidence or not depends upon the facts of the case, the purpose for which it can be used. 2012, volume 6 SEC 174. So in criminal cases, it is always advisable that the finger impressions of the suspects are taken on the orders of magistrates to inspire confidence. That is the only purpose. We know that there is an act called the Identification of Prisoners Act. Under that act, it can be taken. The magistrate can pass an order. 2014, volume 12, SEC 133. Otherwise, what is the evidence that it is his fingerprint? So it is always advisable, or it is to inspire confidence of the court, it is always advisable to take the fingerprints on the orders of the magistrates. The magistrate has been empowered to do so. Now, another area is footprints. Footprints. We have seen that the science of identifying thumb impressions or the finger impressions is an exact science. But in the case of footprints, it is not an exact science. It is a rudimentary science. Much reliance cannot be placed on it. This was so held in 1956. 1956, AR 1956, 415. 415. Though now we are in 2020, I think it has not become an exact science so far. The court can give directions to give footprints. And if the person refuses to do so, an adverse inference may be taken. 2017, 14 SEC 516. 516. Now handwriting. Handwriting also is one of the areas mentioned in section 45. 45. Generally, so how can you prove handwriting of a person or the signature of a person? Section 67 Evidence Act says that, which is the only section which deals with this, the proof of contents of a document. The contents of the, how can you prove the contents of a document is mentioned in section 67. You can prove the contents of a document by proving the handwriting or the signature in it. There may be cases, I have already mentioned that there may be cases in which the documents may not bear, do not bear the signature, or there may be cases where there may not be signature at all, only handwriting, or the handwriting may be of one person and the signature may be of another person, and the author will be the person who signs it, just like a dictation. If the judge gives a dictation and it is a statement is written by the steno and judge signs it, it becomes the statement of the judge, not of the steno or private secretary. So, but what is the mode of proof of handwriting? There are two methods. One is a direct method, the other is the indirect method. Indirect methods. The two direct methods, we can say that the best thing is that the person who wrote it or signed it deposes before the court. Then it is a direct evidence. Then another one is that the person who saw him write or sign deposes before the court. Then you can prove it by the admission of the person who wrote it or signed it under section 21. Under section 21. The other one is section 60. The evidence of the person who wrote it or the evidence of the person who saw him write comes under section 60 because it is the direct evidence. He saw it, he did it. Then coming to the next one, that is section 21, admission. The person who wrote it or signed it has given an admission that it is his handwriting or signature. The next one is section 45, opinion of experts. Then the last one is section 47. We have already seen it. Person acquainted with the handwriting or signature. So these are the methods by which you can prove the handwriting. AR 1979, Supreme Court 24. What is the nature of this evidence? Generally, the evidence in relation to handwriting is of a frail character, it's weak. And its fallibility has been quite often noticed. The court should vary to give too much weight to it. AR 1973, Supreme Court 1346. And in criminal cases, it is always unsafe to convict an accused on the basis of the evidence of handwriting aspects. AR 1964, Supreme Court 1625. It is never conclusive. The opinion of an expert as to the handwriting or signature is never conclusive. AR 1963, Supreme Court 1728. But there is no rule that corroboration is necessary. These are all rules of caution. And in appropriate cases, corroboration should be sought. AR 1980, Supreme Court 531. In which the following sentence can be seen. Court, proceed cautiously. Probe the reasons for the opinion. Consider all the relevant evidence and decide finally to accept or reject it. And again, the Supreme Court has said it is unsafe to convict an accused on the uncorroborated opinion of a handwriting expert. 1977, Supreme Court 1091. Then again in 2016, corroboration necessary. Corroboration of the opinion of handwriting expert is necessary. AR 2016, Supreme Court 4486. Many of these cases actually are criminal cases. In civil cases, we know that a case can be decided on probabilities. So that distinction has to be maintained. Then the question is why it is said to be a weak evidence. What is the reason for the caution? Why the court is reluctant to act upon the evidence of the handwriting aspect? You know that handwriting or signature is always an imitation. And it is always deceptive. It will deceive your eyes. And an artificial thing will look better than a natural thing. You take the case of teeth, artificial teeth. It will be milky white, more whitish than the original one. So it is more beautiful than the original one, artificial one. So this is the reason why I say that generally evidence of handwriting expert is weak one. It is not acceptable as a substantive evidence. Now we come to another area where this sniffer dogs, that is a dog tracking. Now, police investigating officers use these sniffer dogs to identify the accused. So, what is the nature of that evidence? Whether it is relevant, whether it is admissible. The first case it appears is AER 1970 Supreme Court 283. AER 1970 Supreme Court 283. Then the next one is AER 1993 Supreme Court 1723. Then 2001 Volume 6 SEC 205. 205. 2008 Volume 5 SEC 697. I have given all these decisions because all these decisions take the similar view that it is not admissible. The reasons stated are these. One, a dog cannot be examined in court as a witness. The dog cannot be examined. It means that he cannot be cross-examined, or it cannot be cross-examined also. So it is in the nature of hearsay. Then there is a risk of error. There is a risk of error. And the evidence of the person who conducted this investigation, it is hearsay only, because it is not he who identified the accused or the thing, it is the dog. So his evidence is of hearsay nature. These are the reasons stated in these judgments. But you see in 2014, Volume 11 SEC 129, it was taken into account as a circumstance. It was taken into account as a circumstance. We know that yes, hearsay evidence cannot be acted upon even if it is only a circumstance. Hearsay evidence. It cannot be accepted or it cannot be allowed even in cross-examination. And hearsay evidence cannot be taken into consideration. Not only substantive evidence, but it cannot be taken into consideration at all. Normally, exceptions, subject to exceptions. But then, is there any provision relating to it that is not mentioned in this 2014 decision? But I think there is one section which is relevant for this purpose. That is the section 156. Section 156. It is not mentioned in any of the judgments of the Supreme Court. When a witness whom it is intended to corroborate gives evidence of any relevant facts, he may be questioned as to any other circumstances which he observed at or near to the time or place at which such relevant fact occurred. If the court is of opinion that such circumstances he proved would corroborate the testimony of the witness as to the relevant fact which he testifies. Some cases, this is section 156 may attract, though does not always attract. I think this is the only section to some extent which can be applied, section 156. But this is the view now taken. It may be a circumstance that can be taken into consideration. Now we come to another section, that is a section 73 comparison. Section 73. Section 73, it is also of an opinion evidence, but here the difference between this section and the other sections we have already discussed is that it is not the opinion of any witness. It is not the opinion of any witness. See what the section says. In order to ascertain whether a signature or writing or seal is the person by whom it purports to have been written or made any signature or writing or seal admitted or proved to the satisfaction of the court to have been written or made by that person may be compared with the one which is to be proved, although that signature, writing or seal has not been produced or proved for any other purpose. The court may direct any person present in court to write any words or figures for the purpose of enabling the court to compare the words or figures so written with any words or figures alleged to have been written by such person. So for whom to make this exercise clear? For the court to compare the words. So the comparison has to be made by the court under section 73, not by any other person, not by a expert or witness. So it is meant for the court. The exercise has to be undertaken by the court, not by an expert, because expert under section 45, he can do it. That's a different matter. Now, here, what are the areas? Signature, writing, or seal. But the last sentence is, this section applies also with necessary modification to finger impressions. So the court can even compare finger impressions. So 4 things: signature, writing, seal, or thumb impression or finger impressions. These things can be done by the courts. And for that purpose, the court can ask the person, any person who is present in the court, to make a writing or sign in the court. That is usually done. We take the signature or handwriting, the identical portion from the disputed document. He will be asked to write. Then the court will make a comparison. This is what we used to do in this court. Now the court has that power, but it is dangerous. The court has the power, but it is dangerous. AR 1979 Supreme Court 1-4. AR 1996 Supreme Court 1140. Then in another judgment, the court said it is dangerous, hazardous, and risky to record a finding on comparison by the court. 2008, volume 17 SEC 714. And there is a word of caution. Ordinarily, the court shall not do it. But if everything is clear, it may do it. That is AR 79 Supreme Court 14. (2008) 4 SEC 530. In case of slightest doubt, leave it to the expert. That is the advice given by the direction given by the Supreme Court. In case of slightest doubt, leave it to the expert. 1997, volume 7 SEC 110. Then, in another case, the Supreme Court has said, if no expert opinion is made available by the parties did not take any step to get the opinion of an expert, the court shall discharge its duty by entering a finding on comparison. If possible, the court cannot abdicate its power to enter a finding. This is the power given to the court. When a power is given, in appropriate cases, the court has to exercise it. AR 1980 Supreme Court 531. AR 2003 Supreme Court 1796. Then it has already been mentioned that fingerprint also comparison may be made under this section. There is one case reported, that is a compare the finger impressions if the court is in a position to identify the characteristics of the fingerprint. 2008, volume 4 SEC 530. 530. The reason I have already mentioned for these decisions, and imitation is always deceptive. And imitation is always deceptive. But if there are striking dissimilarities, between this disputed and the admitted signatures of the handwriting, okay, it is easy for the court. And there also, we can see that some persons do not put the same signature always. And sometimes there may be some differences between the signatures of the same person. Sometimes it happens. So it is always unsafe. It is always unsafe. So we have now discussed all these provisions, but there is one provision, that is opinion evidence, which has not gained the attention of many. Can you just say which is that provision regarding opinion evidence? I think none of the textbooks that is included in this opinion evidence. That is section 155. 155 clause 1. And that section has not been made use of by anyone in my career of 31 years as a judicial officer, either as the municipal magistrate or this as a high court judge. I have not come across any case in which this section was invoked by any party. That is 155, impeaching credit of witness. The credit of a witness may be impeached in the following ways by the adverse party, or with the consent of the party by the party who calls him. Clause 1. By the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of credit. So the opinion of the witness is that that particular party or witness is not worthy of any credit. He is not a reliable man, he is untrustworthy. That is the opinion he can give in the box. Such a power is given. 155 clause 1. But I have not, as I have told you, I have not come across any situation in which that power has been exercised. But the explanation also is relevant. Explanation. There is an explanation. A witness declaring another witness to be unworthy of credit may not, upon his examination chief, give reasons for his belief, but he may be asked his reasons in the cross-examination, and the answers which he gives cannot be contradicted. Though if they are false, he may be afterwards be charged with giving false evidence. Very, very strange situation. Here we have seen that under section 45, when an expert gives evidence, he has to first give these reasons. If no ground is mentioned as provided in section 51, it is of no use. It is a useless paper. It is useless testimony. So it must precede the opinion. Should these facts or the grounds should precede the opinion. That is the data part. First data part, then opinion part. Here what is stated is this: a witness declaring another witness to be unworthy of credit may not, upon his examination chief, give reasons for his belief. That can be disclosed in cross-examination if that is asked. See? So it is a very strange situation. That is also, we can say that an opinion evidence. Now, I think it is almost 5:30. I have covered almost all the topics except this first one's sections 32 clause 4. There is no discussion in detail because that is unnecessary for the present purpose, lack of time, etc. I think if you have any doubts, I will try to clarified. That does not mean that I have answers for all the questions. I can clear all the doubts.
So we have certain questions in the chat box. I will read it for you. Arvind Kumar, if an unregistered will of A with 4 signatures and without giving notice to his heirs is probated and at a place, and legal heirs obtained a probate on a registered will of A in Bombay High Court, and upon knowing the upon coming to his knowledge of probate passed by Khandwa Court, legal heirs applied for setting aside / revocation of probate of fabricated unregistered will and prayer for appointment of a handwriting expert. Khandwa Court orally asked appellant to produce original will, which is in custody. Please advise.
See, you know that probate proceedings, it is or judgment in a probate proceedings is a judgment in rem. So it is applicable to the entire India. One court, that is sufficient. Okay. So the next question is, it was obtained by committing fraud upon the court. That is a fourth one. So what is the result? It can be revoked. It can be revoked. There cannot be any doubt about it in the Succession Act provides for it. The next question is whether the party can be asked to produce the original. That's the question, I think. The party who has already obtained the probate, whether he can be asked to produce the original. That's the question. Is not that the question? Pardon?
Sir, I will read the question.
The last part. The last part.
So I'm reading that. Coming to the knowledge of probate passed in Khandwa Court, legal heir applied for setting aside / revocation of probate of fabricated unregistered will.
Yes.
And prayed for appointment of handwriting expert. Khandwa Court orally asked appellant to produce original will, which is in the proper custody of Bombay High Court. So what is your take? What should be the way ahead?
Proper custody of
proper custody. Suggestion. Proper custody of Bombay High Court. His case is in Madhya Pradesh. He says what is the proper Bombay Court is. He's saying will from the Bombay High Court should be presented.
Some problem in the audio. I think it is in the custody of the Bombay High Court.
Yes, sir.
Okay.
To produce the original will, which is in the custody of Bombay High Court.
Bombay High Court. Where this proceedings to revoke the will is given?
That is in Madhya Pradesh.
How? It is to be revoked by the same court, I think. Okay.
So his case is that one of the will is forged. It is not his case. I can understand. If you have on the chat box, the question is that referred at by Arvind Kumar. You have the chat box, sir, or I can read the second question, or I can unmute Mr. Arvind.
No, let the author speak. Let the author speak.
Okay, we are unmuting Arvind Kumar.
I understood the question.
Right, sir. We have unmuted Arvind.
Very good evening, sir. May I audible, sir? Yes, sir. Sir, a person died at Mumbai and he had property at Madhya Pradesh, Khandwa district.
Yes.
Their relatives, he was a widower with no issue. That means class 1 heirs were not there.
Yes.
So his relatives, means in-laws relatives, they fabricated will at Khandwa for that Khandwa property, and they obtained the probate at Khandwa district court. And here the class here second class 2 heirs at Mumbai, they filed probate petition on the registered will of a deceased person. So there are 2 wills. In other words, one is unregistered, which is forged with his forged signature, and another is registered will with which is now in the custody of Bombay High Court, because Bombay High Court has also granted the probate, and Khandwa district court also granted the probate. So there are 2 probate of one person.
Yes.
Different wills. Now that signature is totally forged, original documents have been submitted at Khandwa district court, and Khandwa district court orally is asking that bring the original registered will which is in the proper custody of Bombay High.
So
Now they are not giving it. They say that once we had granted probate means it will be in our custody. Let that imperial court, that is at this Madhya Pradesh, they shall come and seek this. We cannot give you. And the low imperial court at this Khandwa, they ask us to produce original one so that we can send handwriting.
Okay.
Yes, sir.
see, the facts appear to be very strange, because the person who obtained this probate on the basis of what will,
Yes, sir.
how is it possible without issuing notice to the natural heirs?
Yeah, no notice is issued.
That itself is a ground to revoke that will. Without issuing notice to natural heirs, that is not possible. Okay,
Right.
even without that, protection of that will can be set aside. It can be revoked. There is no problem. Then we are mainly concerned with the power of the court. See, a court has the power, civil court has the power to summon any document from the custody of any public office. Any
Right.
public office, including a court. Including a court. That court may be Sessions Court, that may be Civil Court, that may be High Court, that may be a Supreme Court. Does not make any difference. So that power is there. But what we do is that instead of issuing a summons, the court will issue a request letter. A request letter will be sent to the court. See, this document is necessary for this purpose. So, in exercise the powers given to you under the CPC or the rules of practice which is applicable there, this document may be sent to this court. So, that request letter has to be returned by the court in which the proceedings is pending. That is the procedure. You come to section 91 in criminal cases, section 91 CRPC.
Right.
That power is given to a magistrate also. You can call for any document or thing from any office, from any officer, including the High Court or the Supreme Court. There is no bar.
Right, sir. Thank you very much, sir. Thank you.
So we have a question from Suganti. She's an assistant professor. But since the question is quite big, I thought there could be break in the chain of the question. So we have unmuted Dr. Suganti. Dr. Suganti, you can ask the question directly.
Hello.
Hello, yes.
Sir, regarding this one registered deed document that is around 1994, okay,
Yes.
Tamil Nadu. Okay, registered deed document that the executor died after 10 years. But
Yes.
after died, then around after then a few years later, then their successor filed a partition case. In
Yes.
that, is a died person husband also
What is this registered document?
that release deed.
Release deed.
Yes, yes.
Releasing his or her share in the property.
Yes, 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 sir.
Yes,
Yes.
yes.
Okay. After that, his husband and daughters claiming, without mentioning that release deed, they are claiming partition.
Hmm.
In that, their father, I mean, that husband of the executor, is one of the witness. He is also with the relating with. He is also asking the partition, hiding that document, and also he is denying that execution. Also, he is one of the witness in that document.
Release
He
deed.
is in the deed, yes.
Yes.
He is also denying his witness also. But another one witness, second witness, he is accepting the execution and also he accepting his signature. He found and accepting his signature.
Yes.
Second witness.
Hmm.
In this case, we need to send to expert opinion or not required.
Actually, it is depends upon the facts of this case.
No, this is the fact I told, na.
Okay, okay.
Yes, sir.
Ordinarily, it is always advisable to send the document for expert opinion.
Okay.
Expert opinion, because otherwise the comparison has to be made by whom? Comparison has to be made by the court. Comparison. So that
Yes.
is always dangerous. That is always dangerous. We have already seen, and there will be conflicting evidence.
Okay.
Naturally, there will be conflicting evidence. One person
Okay.
would say, one witness would say that yes, it is a signature. The other said no, I did not see it. So, in the nature of a conflicting evidence, it is a question of appreciation. So,
Okay.
corroboration is necessary. that corroboration can come from expert opinion, or the court can compare it under section 73.
Okay,
So
sir. Okay.
that is why the Supreme Court said that always try to get this expert opinion. If there is a slightest doubt, leave it to the expert. Let the expert say it. So I think expert opinion is advisable here.
Thank you, sir. Thank you.
So there's one more question. Sir, can you please throw some light? This is by Nidhi. Throw some light on the evidentiary value of DNA evidence with reference to a section 112 of the Evidence Act.
Yes. 1 minute, I may be excused. 1 minute.
Yes.
Yes. See, what does 112 say? 112, I think we need not to discuss it because we are only interested in the DNA. But let us see what it is. Section 112, I will just read it for your benefit. It's a case of a conclusive evidence. Conclusive evidence. Conclusive evidence, we know that it means no contrary evidence can be adduced. But there are two types of conclusive evidences. One, it is absolute. The second, it is not absolute. Some allowance is made. That is a partial lifting of this nature. Conclusive nature is there. So 112 is a case where there can be there is a partial lifting. How it is? The fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. So there is a partial lifting. Partial lifting is that there is one exception. That is when the parties had access. So if it is proved that the parties had no access during this relevant period, section 112 is not actually, there is no conclusive proof. Here one may just ask me one question, or suppose take a case where a soldier from South India left for his office and he comes after 3 years. After 3 years when he comes, he saw his wife sitting on the veranda. There was a 6-month-old baby on her lap. Then he says that, no, this is not my son because I have not come here for 3 years. So there is a proceedings. And it is absolutely proved, perfectly proved that he did not come back to his house for 3 years. Thus section 112 attracts. So you just think of it. 112 is attracted or not is the question. For 3 years, admittedly, he did not come back to his native place. But what is the phrase used? The phrase used is here, parties had no access to each other. And if she proves that, though he did not come back to my native place, I went there. I went there to his place of work. And we had this cohabitation. We had this section proposed. And section 112 is not attracted. Now, this is, the court does not actually allow anyone to prove this bus study because we know that is necessary for family life. That is why this presumption is there, conclusive presumption is there. So, what is the view taken by the Supreme Court in this matter? You know that the DNA is considered a perfect science by the Supreme Court. The Supreme Court has held that it is a perfect science. There cannot be any room for doubt. Just like this, we have seen that thumb impression, science of thumb impression, identifying thumb impression is an exact science. Same view has the Supreme Court has taken. Though in one case, a contrary was taken earlier. Okay. Now, what is the view taken by the Supreme Court? The first decision we can notice is 1993, Volume 3 SEC 418. 1993, Volume 3 SEC 418. The Supreme Court held that if there is a strong prima facie case, then DNA test can be ordered. That means it cannot be ordered at the initial stage. The party has to first establish a strong prima facie case. And if that is established, then he can apply for a DNA test. So there is a condition precedent for ordering this test. That was followed by another decision, that is 2003, volume 10 SEC 22H. That is Amarjit Kaur. Then again 2005.
You should have written this.
2005 4 SEC 449. Then the next one in order is 2010 8 SEC 633. And the last one is 2014 volume 2 SEC 576. In all these cases, the Supreme Court has taken the initial view, which has already been given. That is, unless a strong prima facie case is made out, DNA test cannot be ordered in the case of this where this legitimacy of a person is in question. That was followed. There is only one case which has not mentioned it. That is AER 2001 Supreme Court 2226. 2226, 2226. In that case, the caution given by all other judgments, in other judgments, is not mentioned. But that can be considered as stray judgment, and now it is well settled that it cannot be ordered in a routine matter. That is the phrase used by in one judgment. As a matter of routine, it cannot be ordered. 2010 8 SEC 633. That is relied on in the latest judgment, that is 2014 judgment. So it is well settled that unless a strong prima facie case is made out, DNA test cannot be ordered to defeat the provisions in Section 112 Evidence Act. Yes. I think that is sufficient for you. Okay. Not audible. Not audible.
Said, I was muted. Ali, in some states, forensic departments are headed by IPS officers, and because of this, there are chances that forensic reports against police may not be fair. Are there any guidelines to stop this or not?
It's a statutory provision actually. Statutory provisions, if the conditions mentioned in it are satisfied, the court has no other go but to comply with it. Here, what is stated is that, in the question is that, it is headed by a police officer. The question is not who is the head of the department, because all FSLs are attached to, I think at least in Kerala, it is attached to police department. It is attached to police department. What does the section say? The section says that if the document bears the signature of a particular officer, not the head of the department, it's a particular officer, then it is admissible. The value is attached to the signature of the person whose name is mentioned there. See what is mentioned in section 292. Any document purporting to be a report under the hand of any such officer of any mint of any printing press, etc., etc., then it may be used. Then section 293, that is more relevant for us. The section applies to the following government scientific aspects. The chemical examiner or assistant chemical examiner of the government to the government, not the head of the department. It has to be signed by the assistant chemical examiner or the assistant chemical chief controller of explosives, the director of the fingerprint bureau, then the director, etc. The director, etc. The zoologist to the government, any other government scientific aspect. So the value is to be attached to the signature of the aspect. He need not be the head of the department. Who is the head of the department is irrelevant in such cases. And there may be some suspicious circumstances or doubts about the authenticity in some cases. That is true because it is headed by a police officer. And though in Kerala it is attached to the government, this police department, it comes under the police department. It is not headed by a police officer. I think it is always advisable that a person other than a police officer appointed director of the FSC. For that, initiative has to be taken by the government, not by us. Yes.
Anurag Jain, under what provisions of Evidence Act suggestions to a witness can be given during a testimony?
Pardon?
Sir, under what provisions of Evidence Act suggestions to witness can be given during a testimony?
What can be given?
Suggestions.
Suggestions.
Yes, sir.
Under what section?
Yes. What provision of Evidence Act? Though he's also asking some judgments on these suggestions.
So suggestions are made. Say, you just see section 11. Section 11. Section 11. Facts not otherwise relevant are relevant if they are consistent with any fact in issue or relevant fact. If by themselves or in connection with other facts, they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. So that is one section. So you are making suggestion. That is why we have initially said that the suggestion should be based on the evidence that is available. The suggestion should be based on the evidence that is available. If it is not made on the basis of this evidence that is available, it's of no use. Strictly speaking, that may not be admissible. Then section 156. When a witness whom it is intended to corroborate gives evidence of any relevant fact, he may be questioned as to any other circumstances which he, etc., etc., etc. The court is of the opinion that such you corroborate the testimony. That is only corroboration only. That is the circumstances. Otherwise, section 14 is the relevant section. And in the cross-examination, you know that it need not be confined to the facts mentioned in the examination tip. Then the next one is, as an expert, when suggestion is made, his opinion is sought. So we have seen that under section 46, this opinion which is inconsistent with the opinion expressed also is relevant. So that is why we make the suggestions. We are trying to bring out an inconsistency by making a suggestion. So the appropriate section will be section 11 and section 46.
Thank you, sir. So 2 questions have come on the Facebook also, since we are live on the Facebook. It says by Kumar Madhukal, if in a malicious prosecution against an activist, can a prosecution witness, i.e., that is, police witness who is responsible for the fictitious false case, can be prosecuted? Does it come under the opinion evidence or not?
Oh, in a malicious prosecution case, who is the witness?
Against an activist. Can a prosecution witness, that is police, who is responsible for the fictitious/false case, can be prosecuted? Does it come under the opinion evidence?
Opinion evidence is different from it. Opinion evidence comes a collection of evidence only. So, what is the nature of the allegation fictitious?
It is who is responsible for the fictitious/false case. Primarily not fictitious, false case.
So that means that there is a document. There must be a document. So expert opinion is almost necessary in the case. Otherwise, you must be able to establish that it originated from him in our case. So especially in the case of these electronic records, expert opinion is necessary. Otherwise, it is not possible. But that is an area which we have not considered because the section 45A is there. Section 45A I have not mentioned because section 45A relates to a single officer. It really does not say that it is an expert evidence. But at the same time, it is declared that he is considered an opinion for the purpose of section, for the purpose of this section. Which section? Section 45A. But the section 45A does not speak of expert evidence at all. So there is some confusion in the wording of this section 45A. It applies only to a particular person, officer, that is the examiner of the electronic evidence appointed by the government under section 79A of the Information Technology Act. It applies to that particular officer only. And he is, we can say that because of this provision, he is considered an expert. Only that much we can say. But in all cases of the electronic records, I think it is always advisable to have opinion evidence because it is a highly complicated one.
So since this is going to be 6 o'clock, we will take one last question from Dr. Suganti.
Yes.
We have unmuted her. Dr. Suganti.
Hello.
Yes.
Sir, regarding Evidence Act section 68, there is that provision available, right? If it is registered other than will, if it is registered document, if it is not denied by the executor, then no need to call the attested witness. Here, if suppose one registered gift deed done, then okay, then after 8 years, if the executor died, after that, then their successor is telling that gift deed is not done by the executor. Then if they denied, then that time also as per section 68, one witness need to call or not required. Here the question major part is if the executor is denied only or other than executor if denied also need to call the attested witness as per section 68.
Executor denies.
Executor only.
Eh?
Executor only, sir.
Who denies the execution of the document?
Yes, sir. After 8 years of the executor died, after
right.
execution, 8 years after died. After
died.
Yes, then after 5 years, then their successor is denying the deed.
Okay.
Then that scenario also need to call the attested witness of the gift deed.
Certainly.
As per section 60, as per section 68. Because as per section, if registered document, section 68 telling executor only or anyone denied.
Okay. So the section, there's a proviso to section 68.
Yes.
Section 68 applies to the documents which require attestation. Attestation.
Yes, sir.
And attestation is not defined in this Indian Evidence Act, but it is defined in the TP Act.
Yes, sir. Correct.
TP Act defines it.
Yes,
that means at least 2 witnesses are necessary.
Correct.
Gift deed, mortgage, etc. And this will is another one. Requires compulsorily attestable documents.
Yes, sir. Yes, sir.
So,
correct.
if there is an attesting witness alive,
okay,
then he should be examined to prove it.
But sir, here doubt is, but the line for the line, unless it's execution by the person by whom it purports to have been executed is specifically denied. That last line only, sir, after comma.
Right, right. Unless it's execution by the person by whom the purpose to have been executed is specifically denied.
Yes,
what does
sir.
it mean? It means that if there is no denial of the execution, if there is no denial of the execution by the person who is purported to have executed it, then this it is not necessary to call any attesting witness. If there is no denial, it is not specifically denied, but will is excluded from it. How?
Sorry, sir. Here, this is, excuse me, sir. This is here. The question is for the gift deed, registered gift deed only.
No, see, gift deed or mortgage deed.
Okay.
Because see the the first part of it provided that it shall not be necessary to call an attested witness in proof of the execution of any document not being a will. So the will is taken out of the operation of the proviso.
Yes,
The
sir.
proviso is not applicable to will.
Correct. Yes,
So
sir.
in the case of will, even if it is not specifically denied,
Okay, sir.
you have to call someone an attesting witness. That is it. I
Yes,
think
sir.
I can give you certain rulings if it is with me.
That part fine, sir. But here doubt is, if other than, if will na, even that registered also need to call the attested witness. That is okay, sir. But here in the last line that they are mentioning, right, in the law, that is mentioning, if consider if it is deed, registered gift deed. Okay. Generally, as per Transfer of Property Act, gift deed should have contains 2 witnesses. That is okay. Those are clear. But
Yes.
here that, but the unless its execution by the person by whom it purports to have been executed is specifically denied.
Yes.
This line mentioning, for if you take the gift deed, if the executor after 8 years after execution and registered, then after 8 years died, then for this case, if their successor is denying, in this case we have to call the attested witness or not required.
I think your question is what is the meaning of the word the execution by the person by whom it purpose to have been executed is specifically denied.
Yes, sir. That part. Yeah.
See, here it relates to the person. It does not relate to the person who executed it, but it relates to the person who denies it.
Yes, sir.
That is because of this construction of the sentence.
Yes, sir. Yes, sir. That part. Yes.
Execution is denied not by the person who purported to have executed. The denial should come from the person
Executor, right, sir?
who alleges that it was not written by him, not executed by him.
Yes.
That's
Yes.
how it should be interpreted. The
Okay,
meaning of
so-
the grammatical meaning of this phrase is this: unless it's execution by the person
Who
by
executed,
whom
right, sir?
that means who allegedly executed is
Okay.
specifically denied. By whom? By the party to the proceedings, not by the person who allegedly executed it. Especially in the case of will, he will be no more.
Yes, sir.
So, we can take one last question by Mr. Azad Singh. My question is whether the presiding officer can be called as an expert witness. What is the probative value of the evidence given by the presiding officer?
How can he be called an attesting? He could be an expert in the areas which have been recognized by Section 45 only. We have seen foreign law, science or art, then handwriting, etc., etc., finger impression. In which area he is an expert? Even if it is supposed that he is an expert in law, it will not attract the Section 45. So he cannot be called as an expert witness. There may be some persons who are very experts, but that is an exception. Ordinarily, a presiding officer who is well versed in law, he cannot be called an expert for the purpose of Section 45. How can he be called as a witness? Yes.
Right. Since there's no more question except for one Ali, he says how much period the telephone companies are supposed to maintain the call data records, which can be used as evidence. Is there any guidelines for the same?
No, I do not know anything about it.
Right, sir. Thank you. Sir, there's no further question. Azad Singh questions we have read. So the session, as we at the outset when we had started, we invited you, and thereafter when we had started this webinar, we stated that since we are calling the experts, we will know that there will be good insights. And what we had stated at the outset, when we are giving you the vote of thanks, that belief of our that the session would be very engaging has actually come out truth, because the amount of people are thanking on the chat box as well as on the Facebook. shows that there has been a valuable experience and time during the lockdown has been utilized in the right perspective. It was a different topic, but the way you seamlessly took us through the entire perspective under the law, including the detailed analysis with the section coupled with the judgments. It is a session which people will remember for a long time to come. We are obliged that you gave the inputs, and we would love that sometimes on another topic we can have an enriching experience of you. It is quite understandable that why you were taken in the Judicial Academy, because under Judicial Academy, people who are called to give lectures are invariably those who are expert in the knowledge, because the judicial officers or the other persons who have to learn the legal nuances and the tips can only be given by a person who is an expert. And judicial officers, when they ask questions in the Judicial Academy, they are themselves an expert. To handle them shows the volume of knowledge you have. And thank you to all the participants who have participated in a webinar. Tomorrow we have an engaging webinar again from your platform, only again from Kerala. Tomorrow we have Justice V. Ramkumar and Mr. Prem.
Yes.
An interesting facet, because everyone knows that the Supreme Court had suo moto extended the limitation because of the COVID-19, because as they said that when there are testing times, the powers which are inherent under Article 141 of the Constitution, they extended the limitation. And because of those circumstances, we are also beneficiary where the like Arbitration Act, etc., which could not be extended by any powers under the court. But so tomorrow the session is suo moto extension of limitation in the wake of COVID-19 pandemic, and overview. They will be taking us, pardon sir?
Judicial activism.
Yes. Judicial V. Ramkumar with S.K. Premraj Menon, the advocate who got us connected with you.
Yes. Very learned people.
Pardon sir?
Very learned judge, Justice Ramkumar.
Yes, sir. And I've heard Premraj also speaking on the Prevention of Corruption Act. So the way he presents the things and Mr. Ramkumar presents the thing, it is another facet like what we heard you. Their insights from people like you has always been enriching and engaging for a person, and also encouraging the participants to read more, to learn more, so that they know the judgments which you give are just a bird eye view, but the law is ever flowing. One has to keep on studying and learning. Thank you, everyone. Stay connected. Tomorrow at 6 p.m. again from the Kerala Bar, we will be having two knowledgemen, and we will request, sir, if you get time, we will have also your insights on the topic. We would be too delighted to have you on the platform. Thank you, everyone. Stay safe, stay blessed, and thank you, sir, once again.
Thank you very much.
Very engaging session. Thank you,
but
sir.
The thing is that this class is not meant for any person who is interested in theory. Only for those who are practicing law. Only for practitioners, this my class is intended. Otherwise, they may not get anything from it. So the approach is entirely different.
So the question is only here we have students of law. There are law students. The only subtle difference is that.
Right.
So those who want to be a student of law to keep on learning despite being in the profession is a thing which can be done. Right, sir? Thank you. Thank you once again.
Thank you very much, everyone. Yes.